Welcome. This is our second live webinar for our COVID-19 presentations. Most of you recognize that song. That was the Police singing "Don't Stand So Close to Me." And for a throwback, that is from 1980. Welcome again to our second episode. Again, the news around the country has been nothing but bad. You know, we're getting around, we're coming together, but there's still a lot of suffering out there. And I know there are many people on this chain that are listening, that are having things going on in their family and in their homes. My heart breaks for all of you. We're lucky right now here at Holden Litigation, but I think our day, I'm afraid, will be coming. But we're here today to talk about COVID-19 and litigation. Today's today's presentation is on employment, which is going to be one of the hot topics out of the box. Just like last week's presentation on lost profits, this one is going to be big, quick, and keep rolling. Really, the way we're seeing it shape up now is that workers' comp, will be the third big role. Putting these together, the EPL and the comp are going to get some overlap, not so much today, but in how it's handled. We have our first report from the Holden Institute at Bletchley Park. They do a lot of research for us. Our team looking at what's going on around the country, and it's just a brief, quick update, so we all see what's going on. Very interesting that 6 more states have granted immunity to the nursing home industry. We're looking into that to see what type of immunity and to what degree. I think we'll be seeing that coming toward the medical community too, especially the ER folks. Students have filed a class action lawsuit in New York for failing to refund their fees because they couldn't go to on-campus classes. So that will be interesting to track. A Texas theater owner has sued the Lloyd's of London for a $1 million pandemic event policy marketed after the 2014 Ebola outbreak. I want to look into that a little closer. I don't know that Lloyd's actually marketed it as a pandemic event policy or if the plaintiff attorney called it that. Last, from the Holden Institute's Travelers Insurance files a suit against a law firm seeking a deck action that the firm could not cover for COVID-19 losses because they're not, quote, physical loss or damage, unquote, to the firm's offices. Nothing new there. That's going to happen on coverages all around the waterfront. Let me tell you, just to get this set up, this episode is live, as you can probably guess now, or some of this would have been cut out. The episode is going to be on starting 12:30 Eastern Time, 9:30 Pacific Time, on April 28, 2020. Please note that these are Holden Litigation's thoughts, recommendations, and current opinions. That means as of today, 4/28/20, these opinions are good. They're going to be as good as you'll get in the country. We stay up on this. But some of these may be starting to get stale by this time in the morning. That is how fast this all is moving. It's moving like the COVID virus. We have 3 lawyers and 2 paralegals that do nothing but work on COVID updates. This is not legal advice, but it is stuff you can rely on. Don't hesitate to call us, email us with questions. We've answered probably 50 this week. Well, the end of last week and this week so far. And that's really what we're here for. Don't forget, if you have a question, type it into the Q&A box up on their screen. We will answer as many of those as we can in the 4-minute round at the end, but we don't get to them all, can't. But what we do is we list those we used today, and we also list other questions we didn't get to on our FAQ on our website. So our website is kept up to date and it's ready to roll. All right, ladies and gentlemen, as they say, without further ado, I want to introduce you to Rebecca Woodward. Rebecca is the head of our employment practices group at Holden Litigation. She's actually, early in her legal career, she was a legal assistant to a Supreme Court Justice, Arthur Goldberg. Now, in fairness, Arthur Goldberg was not the Supreme Court Justice at the time she was a legal assistant to him. He actually was in the 60s. He withdrew from the Supreme Court for an appointment to the UN as ambassador because in the mid-60s, he had this idea that he could help end the Vietnam War. He tried, he didn't make it. He's not credited with ending the Vietnam War, but Rebecca did work with him for a couple of years. And then she went on to work for a federal judge in Houston. Now, many of you Texans that are on here will recognize Judge Karen Brown's name. She was well known down there. She's retired now, I believe, but very well known, very well respected there in the Southern District of Texas. After Rebecca left the federal district court, she went to work at Vinson and Elkins for a while, and then she went into employment practices defense. And for the past 25 plus years, that has been Rebecca's focus. You will find that there isn't anyone in the country that know as much about employment practices as Rebecca Woodward. There are a lot of good lawyers out there that know as much, but she has these answers. So with that said, Rebecca, would you please join in and present for the ladies and gentlemen?
Certainly will. Thank you, Steve. I'm here today to talk about a couple of issues related specifically to employment discrimination. And as we all know today, there has never been a more challenging time for employers than today, navigating the waters of the coronavirus pandemic and making decisions which will affect the very survival of the company. Unfortunately, these decisions and the environment in which we find ourselves today is absolutely fertile ground for employment discrimination claims. The Equal Opportunity Employment Commission, or the EEOC, has made it crystal clear that they intend to continue during this pandemic to enforce anti-discrimination laws and also to address issues which arise because of the pandemic. Now, the following are some laws I want to discuss, three specific laws I'd like to discuss during our presentation today. This is obviously not a comprehensive list of employment discrimination laws, but I think they're pertinent to what I want to focus on in our short time here. And the first is Title VII of the Civil Rights Act of '64, which of course prohibits discrimination against an employee on the basis of race, color, religion, national origin, or sex. The Age Discrimination in Employee Act, which protects people who are 40 or older from discrimination because of age in the workplace. And the Americans with Disabilities Act, which makes it illegal to discriminate against a qualified person with a disability. These and a myriad of other state and federal laws relate to every single aspect of employment virtually, from the application process to hiring to training to promotion. And in particular here, I think I'd like to focus on how these apply to layoffs, furloughs, reductions in force, calling people back to work, and then the environment of the workplace upon return. The first thing I'd like to focus on, well, there's two hotspots I'd like to focus on, and the first one is layoffs, reductions in force, or RIFs, furloughs, and then bringing people back to work. And I may use those terms interchangeably. As we all know, employers are reducing their workforce and laying off people in record numbers. I believe last Friday, the number of unemployment claims was topping 26 million. And in real numbers, we have a 20% unemployment rate in the United States of America right now. Those numbers are just shocking. Also, we know that these numbers may go up as businesses continue to struggle with the pandemic. What we also know, and what has been my experience, that the vast majority of EEOC claims and employment discrimination cases occur upon a person's separation from employment. So we're looking at 26 million people who have been separated from employment and we look at the fact that most EEOC charges and cases of discrimination occur after termination from employment, the potential pool for claimants here, the potential number of claims is literally staggering. None of us know what's going to happen in the future with these claims, but we can all understand the incredible potential for an upsurge in these kind of claims. Now, an employer can use any criteria it wants to select employees for furlough or layoffs, provided that the employer does not make the decision based on characteristics of a protected class, i.e. an employee's age, disability, race, gender, which includes pregnancy or pregnancy discrimination, or any other class protected by state or federal law. Now let's take an example, and this is something I've actually seen. An employer chooses for layoff during this pandemic older workers, pregnant workers, and those who have underlying health conditions. That criteria is discriminatory on its face. In fact, if an employer actually selected only older workers, pregnant workers, and people with underlying health conditions, they've hit the employment discrimination trifecta, because they're probably in violation of Title VII, the ADA, and the ADEA. Although it was well-intentioned, trying to protect people from COVID-19 and choosing people on that basis to protect them, it's discriminatory on its face because the decision was made based on characteristics of 3 protected classes. This would not be my favorite employment law case if I got it. Luckily, I don't think we're going to see this kind of clear, blatant discrimination with layoffs. What we are seeing is people who are, for example, eliminating a position that can't be done remotely, or reducing their force based on seniority, job performance, etc. While this kind of criteria is neutral on its face and not discriminatory on its face, it can be discriminatory and a subject of a discrimination claim if the implementation of an otherwise satisfactory criteria, not based on the characteristics of a protected class, disproportionately impacts and discriminates against a protected class upon its implementation. On the surface, it's fine, but when it's implemented, it disproportionately impacts a class. Let's take, for example, an employer who decides to lay off its last hires, let's say its last 500 hires, because of budget constraints. Normally, that employer has about a 30% female workforce. But the group in which the employer selected, that is the last hired, say 85% of that group, is included in the group to be laid off. While that's a neutral criteria, that is, you've used the people who were last hired, the group of people who were last hired, it disproportionately and discriminatorily impacts a protected class, which is, in this case, women. The EEOC has provided guidance for employers, and really we're talking about larger scale layoffs here, and has suggested, and which is always a good idea, that for widespread layoffs, employers should use an impact analysis or conduct an impact analysis. This is fairly simple. First, the employer lists the employees who would be laid off or furloughed based on the determined criteria, then determine whether certain groups are affected more than other groups based on this criteria, and if so, see if the criteria for the layoff or the reduction in force can be adjusted so that these groups are less impacted. Back to our example of females, where we have a disproportionate amount who are in the group to be laid off. An employer should determine whether it can adjust its criteria, and instead of using the people who were last hired, perhaps use job performance, profitability, expertise, etc., to see if it can lessen the impact on protected classes while still meeting their financial needs. These are real world problems that are not easy to address and not easy to resolve. But in the environment we are in today, when we are talking about such large scales of layoffs and furloughs and so many potential claimants involved, it's really important that employers pay attention here. In my experience, there are 2 things that will either stave off employment claims to protect an employer, or make it much easier to defend employment discrimination cases. And the first one is documentation in every kind of employment case. So when employers are making these large reductions in force or layoffs, it's important that they document the basis for it, that they, if they do a RIF, state the reasons for, state the reasons when you're calling people back to work, and make sure that's not discriminatory as well. And if an impact analysis is done, and state the basis for that too. That will come in very handy in the defense of the case. So we talked about RIFs, or situations where large amounts of employees are laid off and large amounts of employees come back to work. The second area I'd like to talk about is deterring discrimination against employees upon return to work. Like people of Middle Eastern descent endured after 9/11, we have all heard stories around our country, unfortunately, about people of Chinese or Asian descent being the victims of derogatory terms, racial slurs, or even violence during this pandemic. The EEOC chair, Janet Dillon, has released a statement warning that these actions could and will result in unlawful discrimination claims on the basis of national origin or race. To guard against this harassing and discriminatory behavior toward this group of employees, it's important that an employer remind all employees in writing that such harassment will not be tolerated. I said a moment ago that there are two things that I feel are most important in the defense or stopping employment litigation claims to begin with. The first is documentation, the second is communication. And this is a prime example of that. When a workforce is coming back, things like this need to be made very clear and be done in writing. It's also a good time for employers to review their anti-discrimination, anti-harassment policies to ensure they include a comprehensive reporting process, and complaints should be investigated and proper action should be taken consistent with the employer's own policies. Next one about discrimination against employees who test positive for COVID-19. Because of the fear surrounding the pandemic, there is concern that employees who return to work after a positive test, a presumptively positive test, or after caring for a family member with the virus may be subject to discrimination or harassment based on the employee's actual or perceived disability. Those are the buzzwords: actual or perceived disability, which can bootstrap harassment against such a person into an ADA claim.
Rebecca?
Yes, sir.
Let me break in on you now because it's, and I know you could go all day. I've sat in your office and talked with you, and you can talk this all day. We try to keep it limited and well, I would say unfortunately, but fortunately we've got a ton of questions. What I want to do so we can cover some ground quick, I want to go to what I'm going to call the lightning round. So don't be concerned, Rebecca. Just kind of, I won't say off the top of your head, but your best judgment to some of these questions in just a couple of sentences, and then I want to move on to the next one. Okay?
Sure.
What about forcing temperature checks? You know, the employer forcing temperature checks at the workplace.
Well, let me go real quickly. While normally the ADA precludes against broad medical testing or broad medical questions because it's not job related or business necessity, last week the EEOC issued guidance on steps that can be taken which will not violate provisions of the ADA during the pandemic. And on this slide it shows several things that can be done. You can require a doctor's note. You can withdraw an offer. You can take the temperature of employees that was specifically recognized. You can ask an employee if they're experiencing symptoms, bar an employee from the workplace, and require that a test be taken.
Rebecca.
Yes, sir.
You're violating my lightning.
No, I apologize.
You're going into the full explanation. We don't have time for that.
Understood.
Employee remains fearful of contracting the virus and simply refuses to come back to work.
That's a really good question. I think that
There's one sentence.
once businesses are allowed to return to work, the employers are not required necessarily to accommodate employees unless the employer requires accommodation separately under the ADA or those who are vulnerable, such as the elderly or people with underlying conditions.
Okay. Here's one from New York. Can an employer decide which employees are allowed back to work and which employees are not allowed back to work?
As a general proposition, absolutely. As relates to COVID-19, if an employee is showing symptoms, employers have the right to send that employee home or prevent them from coming to work. However, if an employer tries to pick and choose employees based on age and who is less vulnerable, that will cause legal ramifications.
Thank you, Rebecca. Let me finish up here so people can get on with their day. I like to give kind of what I call the jury insight and what will happen on some of this. It's very interesting what Rebecca says. You have an ADA claim if you're saying you can't come back because you're older. But I don't think our juries are going to say, well, we're going to give them a lot of money because, they're older, they've been discriminated against. Well, why were they discriminated against? Because we didn't want them to get sick and lead to others getting sick. I don't think juries are going to punish the employer for that deal. The problem here for employment and employers is the quagmire for the employees, how to open up without causing EPL problems like the testing and the gun and the whole 9 yards. But then you get into the comp sector when they come and then they get sick. What happens? Then they sue under the comp that they weren't protected. It is a quagmire. Ladies and gentlemen, I appreciate you joining us today. We've had fun. Fun's not a good word in the days of COVID, I'm sorry. For lawyers, it's been an interesting time pulling these things together and tracking them almost like a ticker on a machine. And we will continue to do that. Our next presentation is Thursday. It's on long-term care medical. And then we've got a special one Friday that we've got a neurosurgeon and an internist joining us. And it's really a lot about EPL unemployment sides too, and how to do proper testing, that sort of thing. That's going to go for about 90 minutes. So if you want to join us for that one, that's a special edition. But we just think we think now's the time to do it. We had it set for next week and we bumped it up. It is just too important right now. Ladies and gentlemen, thank you for joining us and have a good day and stay safe, okay? Bye-bye.